I just wrapped up another wellness law podcast interview, this time with Christopher Barneveld, who is an attorney at the Pacific Legal Foundation. And he's one of the lawyers who is suing the California Board of Psychology and representing Anna Runkle, who is the crappy childhood fairy. And I think I've talked about that in previous videos on this feed. And I just wanted to give you guys, the subscribers, a few highlights from the upcoming podcast. It's not published yet. It will be probably in a couple of weeks. Today is July 9th. And so I'm guessing before the end of July, the podcast recording will be up for viewing on YouTube or listening on your favorite podcast channel. The Pacific Legal Foundation, I didn't really know a whole lot about them before the podcast. My mistake. Even though they're Pacific Legal Foundation and they were founded in California and based in Sacramento, they do have offices all over the country, and they do help people with First Amendment, particularly issues all across the whole country. And so they do this pro bono, meaning they are free. The lawyers are free. They bring these constitutional type cases and challenge government intrusion into individual liberties. That's their focus. So that was really cool to learn a little bit more about that public interest law firm, the Pacific Legal Foundation. And we talk about this in the podcast about how the work that they're doing in the courts is basically in acting out what I talk about in theory in my law review article. So it's really cool for me to see my work actually in action, and then possibly using some of the information and research that I've done in writing those law review articles for helping them with their case. And another highlight I wanted to raise is that speech-heavy occupations, wellness coaching is one of those occupations where a lot of work is done primarily through talking with other people, talking with friends, giving webinars and group coaching sessions. But it's not the only one. There's a lot of occupations that are primarily speech. That's what people do for their work. Consultants, for example, not even just wellness coaching and consulting, but I'm talking like business consulting. Big organizations hire Deloitte and PricewaterhouseCoopers and Ernst & Young, come in and guide them through strategy sessions. And interestingly, that kind of work would fit within the definition of the practice of psychology as the California Board of Psychology has defined it, which includes intervening to increase effective functioning of individuals, groups, and organizations. So if your work includes intervening to increase effective functioning of organizations, and I know a lot of people in and outside of the wellness industry, that's what they do. They go into organizations to help increase effective functioning. Maybe it's increasing better leadership, improving communications within staff. All that stuff technically would be the practice of psychology, and you can't do it in California unless you're licensed to practice psychology. That is the law that the Pacific Legal Foundation is challenging in the Anna Runkle v. Leah Tate lawsuit. And I guess they just filed their preliminary injunction last week, which means they're asking the court to stop the California Board of Psychology from pursuing, penalizing people for doing what Anna Runkle was doing, which is trying to help people with improve their functioning, even if they've had childhood trauma. I'll be following that case quite closely, but I thought it was important to point out that this goes way beyond health coaching and lifestyle coaching or life coaching to very legitimate, long-standing consulting firms and businesses that are at risk, technically, with this very broadly worded statute that defines the practice of psychology. And also the last point I wanted to make was that the person, how Anna Runkle, the crappy childhood fairy, got in trouble with the California Board of Psychology in the first place was that someone attended one of her webinars and decided that she was practicing psychology in California without a license. We don't know who this person was. They were not a client of Anna's, and they weren't harmed. And I think that's another important point. The person who complained wasn't harmed. Nothing Anna said, caused this person harm. It was just a technical violation that she didn't have a license to practice psychology, and what the work she was doing fits within the very broad definition of what California considers to be the practice of psychology. And that is a very typical way that these complaints arise, and that the attention of a licensing board would be drawn to is that someone complains who sees this person as a threat, not to harm people, but a threat to the occupation, reports them to the licensing board. So those were the highlights I wanted to raise with the upcoming podcast that you will be able to listen to hopefully by the end of July. And I just thought it was really fascinating, and thanks for tuning in.